Making a mention, my lord. Hearing item number 5.
Hearing item number 5.
Yes, my lord.
Okay. Not very well because of the weather. I had fever. Okay. So item number 5 of part 2.
Yes, my lord.
RFA
RFA, my lord, 16 of
2013. See?
Yes, my lord.
Do it.
My lord, the reason is that my senior Mrs. Dinari is in bereavement. Her mother passed away last Friday.
Okay.
So if this may be adjourned for 2 weeks, my lord.
Okay.
I have taken the consent of the other party.
Otherwise, it's a very old matter.
We have been attempting to dispose it on many occasions, my lord.
Acha, acha. So who is in bereavement, you said?
Mrs. Dinari T. Aju, counsel for respondent number 7.
Okay. Oh, Dinari. What happened? Who's died? Who died?
Her mother.
His mother?
Her mother.
Oh, okay, okay. Right. Heard Mr.
Victor.
Victor L. Ralte for the respondent, right?
Yes, my lord.
For
Respondent
the
number
respondent
7.
number 7.
Yes, my lord.
For respondent number 7, Mr. Victor submits that the conducting counsel, Mr. Dinari T. Aziu, is in bereavement and as such has prayed for some time. Prayer is allowed. List this matter.
After vacation, my lord.
After vacation, right? Okay, so after vacation, vacation is here for only 1 week.
Yes, my lord.
So on 8th or 15th, whatever you say?
On the second week, my lord.
Okay, then, okay, on 8th, right?
My lord.
On 9th.
Yes, my lord,
Thursday.
9th.
9th, on 9th of October, 2025.
And similar prayer in respect of item number 6. Here, on behalf of the appellant.
Okay, yes. Heard Mr. Victor Erralte for the petitioner. Mr. Victor submits that Dinari T. Aziu, Mr. Dinari T. Aziu, appearing for the petitioner, is in bereavement and as such has prayed for some time. Prayer is allowed. List this matter. This is also RFA of 2015. So list this matter on 16th of October?
Yes, my lord.
16th of October, 2025.
Deeply obliged.
Yes, Mr.
Your Lordship, regarding item 8, Your Lordship,
8.
yes, if the matter can be taken up after 3 weeks, Your Lordship, and in the meantime, we'll be filing our IA in this matter.
I for suspension.
IA for, yes, Your Lordship.
But in 2020 matter, what is the scope of suspension now after 5 years?
Actually, Your Lordship, not suspension, we would want to remand the matter back to the trial court because he was deprived of any evidence, taking any defense evidence, Your Lordship. So on that point, we want to file an IA.
Acha, no defense evidence
No
was
defense
allowed.
evidence, yes.
But then he must have been asked whether he is likely to produce defense in his 313.
The thing is, Your Lordship, his counsel, father was one of the prosecution witness.
Oh.
So his counsel did not take any evidence.
Oh, he should have recused.
He knew that only after the judgment.
Acha, acha. Okay. Heard Mr. Jonathan L. Silo for the petitioner, for the appellant. And okay. And Miss, there's no PP today?
No, Your Lordship.
Zorang Sampui is not a PP. You are not a PP, right?
No, Your Lordship. She is a CGC.
Acha. And then, right, a prayer is made by Mr. Silo to take up the matter on a later date. Prayer is allowed. List this matter on.
For 3 weeks.
It will again go after vacation, I think.
Yes, Your Lordship.
So, list this matter on 16th of October again.
Your Lordship, if 21 will be, because...
21, okay, 21st.
Yes, Your Lordship.
21st of October.
Oblige, Your Lordship.
May it please, Your Lordship, I seek indulgence in mentioning item number 3 and 4 of the hearing, Your Lordship. Hearing list, Your Lordship.
Hearing list?
Yes, Your Lordship. 3 and 4.
Okay.
I've taken the consent of the other party, Your Lordship.
Again 2013 matter.
Yes, Your
such a
Lordship. This matter has actually been handled by Mrs. Caroline, and she is on maternity leave in this. She's on maternity leave, so if the matter may be listed again after the ensuing vacations, Your Lordship.
Okay. Right, Miss, I forgot your name.
Lalun Lu, Your Lordship.
Lalun Pui for the petitioner, for the appellant. And, okay. Who
For the
makes
respondents, Your Lordship. We are for the respondents, Your Lordship.
You are for the respondent?
Yes, Your Lordship.
So
I'm for the appellant, my lord.
Okay. For the respondent, who makes a prayer for adjournment of the matter. Your name is reflected here. Your name
My
is-
lord, Sitlan Thiang Lima.
C. Lalrang Renga.
Sitlan Thiang
No,
Lima.
no. C. Thang Thiang Lima for the petitioner. List this matter on again in October, I believe.
Yes, Your Lordship.
On 16th of October.
In the week commencing from 13, my lord, yes.
Yeah, we
Yes,
commencing
yes,
from
my lord,
13th.
yes.
So 16th of October, it's a Thursday.
My lord,
16th of October.
oblige.
Your Lordship,
Yes.
may I seek indulgence with regard to item 14 of the hearing list?
14.
1-4 of 14,
Okay,
yes.
okay, it's
May
a
it be
criminal-
fixed for hearing on,
It's a criminal appeal, perhaps POXO matter.
yes,
Legal aid is also there. So when do you want to do?
Thursday or,
This Thursday?
yes.
Okay. This Thursday, it's okay. This list is there till Friday. Thursday, it will be called.
Yes,
Yes.
oblige, Your Lordship.
Daily list for motion, item 1.
May I please, Your Lordship? My Lord, this is a contempt petition filed against the respondent for the non-compliance of this honorable court order in WPC.
What is the court order? Where is that?
This honorable court has directed the district collector to make, the order is at page number 15 to 53. The operative part is at from page 50 to 53. Para number
Achha,
8.
district collector to specify the amount.
Yes, my lord.
Then submit it. Then the collector to undertake the exercise of reassessment.
Yes, my
Nothing
lord.
has been done. This is order dated.
My lord, the collector has done his part and approval was also received from the government of Mizoram.
Approval is also obtained.
Yes, my lord.
Thereafter, nothing is done.
Yes, nothing is done by the respondent number 1 to 3, even after the expiry of the period given by this honorable court.
So after that fund was not, these respondents had not arranged for the funds and all.
Yes,
After
my lord.
approval, nothing is done.
Yes, my lord.
So 3 and 4 is not complied with.
Respondent number 1 to 3 has not
No,
complied.
3 and 4 of the judgment. The direction in paragraph 3 and 4 are not complied with.
Yes, my lord.
1 and 2 are okay.
Yes.
Okay. Your miss?
Vanel Swami.
Yes. Miss Sunj, for the petitioner, for the petitioners. This is a contempt application filed for for non-compliance of the order dated 21/11/24.
Yes, my lord.
21/11/24, by which
In WPC number 125 of
Acha,
2021.
yes, passed in WPC, passed in WPC number 125 of 2021, by which 4 directions were given by this court, and they are that the petitioners within a period of 3 weeks would submit their applications before the district collector, giving the details of their land, along with the amount, along with specifying the amount that they had already received because of the acquisitions made, and that thereafter the district collector, on receipt of such applications, was directed to undertake the exercise of reassessment of the compensation amount. by applying the provisions of 2013 Act, by applying the provisions of Land Acquisition, Rehabilitation and Resettlement Act 2013. Within a period of 3 months, and that thereafter the collector shall obtain the approval of the competent authority
Yes,
in the
ma'am.
state government and would forward the same to the Union of India, represented by Secretary to the Government of India, comma, the Chief Engineer Border Road Task Force, comma, no, not comma, and the Executive Engineer Civil Officer, who upon receipt of the assessment shall make necessary arrangement of the funds and deposit the same before the collector within 3 months. And that the same may be disbursed to the landowners without delay. A further direction was also given by the said order, by which the application submitted by the petitioners before the district collector shall be treated as an application for reference, and the collector may forward it to the authority constituted under the, this is 2000, oh no, constituted under the Land Acquisition you said right, before the authority, that is Land Acquisition, Rehabilitation and Resettlement Authority. Full stop. However, the petitioner appearing for the petitioner appearing for the contempt petition submits that the first two directions have been complied with, that is, the petitioners have submitted their applications, right?
Yes, my lord. On
And-
6/12/2024.
On 6/12/2024, along with the required amount specified, as well as the amount, as the amount specified, as well as the ground for not accepting the already, as well as the amount, as well as the ground, for not accepting the award, not accepting by giving reasons. Why the amount awarded is not accepted by giving reasons other than application, and by showing the grounds for non-receipt of the awarded amount. Full stop. Further, it has also been submitted that the district collector, in pursuance to the said order, has also reassessed the compensation amount, and the same
has been approved by
yes, and the same that was done within 3 months, right?
Yes, my lord.
Okay. And the same has also been approved by the competent authority as per 2013 Act. Full stop. However, she submits that the that the further communication that must have also been communicated, but then they did not do it, right? The fund was not
Yes, my
arranged
lord.
and all. But she submits that as required under the third direction, that the authorities will make the necessary arrangement for funds and deposit the same within 3 months to the collector was not done, right? It was not done. Neither the amount was not done, and further the rest of the directions. Reissue notice to how many, what is the respondents here?
Respondent number 1 to 7.
Issue notice to respondent number 1 to 7 by registered post with AD or with usual process. The petitioner to take steps within 3 days from today.
Yes, my lord.
List this matter with AD returnable within 3 weeks. Make it returnable within 3 weeks. She will take steps within 3 days. List this matter after 3 weeks. After 3 weeks, on a date to be fixed by the registry.
Oblige.
Item 2.
Yes, Mr. Malhotra.
May I please, Your Lordship? The grievance of the petitioner is non-payment of rental compensation by the respondents number 5, 6 and 7 for occupying his land in spite of several directions by the Honorable Court to pay the rental compensation. In fact, Your Lordship, initially the petitioner had filed a suit claiming rental compensation from the respondents 5, 6 and 7.
Okay, today notices will go. Let the notices be issued. There are around 7 respondents. Okay, right. Heard Mr. A.R. Malhotra for the petitioner. And, okay, so for the petitioner. Land was occupied by 5, 6, 7, right?
Yes, Your Lordship. In fact, Your Lordship, mainly the grievance is against the respondents 5 and 6 and 7.
5, 6 and 7.
Yes.
They were occupying but they did not pay the rental compensation.
Initially, they did not pay. We filed a suit. Accordingly, the suit was decreed in favor of the petitioner, whereby the respondents were directed to pay the rental compensation from 86 to 2005, which was already assessed. And the state respondents were directed to make further assessment for the period subsequent to 2005. So, but they filed an appeal, which was rejected. They filed a review, which was rejected. Then we filed an execution. In the execution, they paid the first installment till 2005. But
2005 you said it was already...
it is paid. Then the further rental compensation from 2006 onwards, respondents 5, 6 and 7 claimed that the land in question was handed over to Assam Rifles. And Assam Rifles being under the Ministry of Home, the liability has shifted. And they filed a CRP. But in the civil revision petition, this Honorable Court held that this issue was never raised before the trial court. And they cannot raise it at this stage. And it is an internal matter between the two departments of the Government of India. It should be settled between them. If I may take your lordship to the judgment of this Honorable Court at page 72, they have also filed a civil revision petition.
Yes.
And I'll take your lordship to page 75, para 6. If I may read para 6, Your Lordship.
Yes. Okay.
As pointed out, it appears that the petitioners are respondents 5, 6 and 7, had initially challenged the judgment and order dated 20th of August 2009 by filing RFA 14 of 2010, which however was dismissed by judgment and order dated 22/3/2013. Subsequently, review petition 3 of 14 along with CMA 226 of 2014 was also dismissed by this court. In the execution case 40 of 2013, it is seen that the petitioners had nowhere taken the plea that it is not them who are liable to compensate the respondent number 1, but Home Ministry. After a direction was passed not only in the civil suit, but also in the execution case 40 of 2013, it will not be open for the petitioners to now take a new plea that they are not liable to pay compensation in view of the fact that the land is occupied by Assam Rifles for the period concerned. As relied upon by the Council for Respondent number 1, the Apex Court in Chief Conservator of Forests, Supra, has held that interdepartmental disputes, whether it be a state or Union of India, should be resolved at the government level and should not be brought to the court. Similarly, in the instant case as well, if the Defence Ministry thinks that it is the Assam Rifles who are to pay compensation, since they are not the one in occupation of the land for the period concerned, It is for them to take up the matter with the Home Ministry. So in spite of this, Your Worship, payment has not been made, and we are running from pillar to post, and they are just delaying the matter, saying that matter is being taken up with the Assam Rifles Ministry of Home. But as per the decree, it is their liability. And if they have handed over the Defense Ministry, and if the Defense Ministry has handed over the land to the Assam Rifles under the Home Ministry, it is for them to settle their internal dispute.
Yes. But the 2006 onwards you were not paid, right?
Yes, 2006.
My lord, if I may, the present writ petition is not maintainable because the petitioner already filed civil suit 23 of 2006 and the order has been passed and execution petition had already been filed by the petitioner and is going. The present writ petitioner trying to use this cause as executing court. However, they cannot use writ court as executing court, my lord. Order already been there and execution case already been filed. Then if the respondent not yet complied with, they have to approach again executing
I think
court.
there is a violation of Article 14 here. Those things will come. 300 also, I think.
300A.
300A.
Your Worship,
Not like an executing court, but because they were not paid and the tussle is between the Defense and the Home Ministry, they should settle the matter. Who will pay?
Then they can approach again executing court, my lord.
What happened to the execution
Your Worship,
proceeding?
on 2 occasions we have filed execution petitions. On both times, the executing court has directed them to pay the rent. But they are not complying with it. We are remedialist now. And the Supreme Court has held that when there is no remedy, 2 to 6 lies. It is very clear. If Your Lordship will see the last order of the Annexure 12, page 109.
Let the reply come from all the
Yes.
parties. Heard Mr. A.R. Malhotra for the petitioner and Mr. Jazairang Sampui for the state respondent, right?
No,
Number
5, 6 and 7.
5, 6 and 7.
Yes, my lord.
5, 6.
State is 1 to 4.
Acha, you are there for Mr. 1 to 4. This petition is filed under Article 226, right? Under
Yes.
Article 226 of the Constitution of India for issuance of a writ in the nature of mandamus. Comma certiorari for violation of the petitioner's fundamental rights under Article 14 and 300A of the Constitution of India. It is the case of the petitioner that the petitioner's land were occupied by respondent number 5, 6 and 7, right? 5, 6 and 7, and that they were paid initially the rental compensation
Till December 2005.
from 1986.
Yes.
From 1/9/1986 to 31/12/2005.
Yes.
It is also stated by the petitioners that the said rental compensation was paid in pursuant to the case filed by them. A civil case was filed by you.
Yes, civil suit.
A civil suit was filed by them. They further state that thereafter, that is after 1/1/2006, the petitioners were not paid the rental compensation by respondent number 5, 6 and 7. On the ground that they are not liable to pay and that the defense, the 5, 6 and 7 are who?
The
These
Defense
are
Ministry.
and that the Assam Rifles,
Under the Ministry of Home.
Assam Rifles under the Ministry of Home should pay.
Yes, that is
Assam Rifles under the Ministry of Home are entitled to pay the said rental compensation. Issue notice to respondent number 1 to 3 are represented, only 4 remains or what?
No, 1 to 4 are state, yeah.
Oh, 1 to 4. Your name I forgot? Samuel, yes. Mr. Samuel appears for respondent number 1 to 4, and Ms. Zairang Sangpui appears for 5 to 7. And as such, no formal notice is required to be served upon them. However, extra copies may be given to them by the petitioners. List this matter after 2 weeks or 3 weeks, whatever.
3 weeks.
You will file affidavit? Ms. Zairang Sangpui prays that she may file affidavit. You will also?
I'll have to seek instruction.
Acha, okay. List this matter after 3 weeks on a date to be fixed by the registry.
Obliged.
For admission, items 3 and 4.
Further, Ms. Jairang Sangpui has raised the issue of maintainability of the instant case, which is left open for adjudication later. This is item 3 and 4. Wait, there is a note. I think I've kept it there or what? Yes, yes. Yes, 3 and 4. These are again contempt.
Yes, Lordship.
The
Lordship, in
matter
this case,
pertains to rental
I am appearing
compensation.
for,
You were supposed to, yes, Mr. Kyal.
I have obtained instruction, Lordship.
Okay. For non-compliance of this, right? What is the order here?
The order was passed on 2014, my lord. The direction was
2014.
Yes, my lord. It's regarding rental compensation.
2014 until now
And
nothing.
yes, my lord.
Compensation for acquisition.
And rental compensation. And in the year 2015, the respondents themselves had filed IA for extension of time for compliance of the order. In spite of that, my lord, in spite of granting 6 weeks times, we are still in this stage, my lord.
He has placed one instruction. Let me see. Have you got it?
No, my lord.
You can give him a copy, Mr. Kyal.
Thank you.
What is blueprint area? I don't know.
See, there was a blueprint was made by the authorities to see whether the land were occupied under the different armed forces or not.
Armed forces. Where is the directions? Where is the 2014 order? Page?
Page number 13 of my contempt petition.
30?
13, my lord. And moreover, my lord, the letter dated 2nd September, which was submitted by my learned friend, it appears that it pertains to the item number 4, not the present one.
Acha, let me see the order first.
Yes, my lord.
This
Page
is
number 13, contempt petition number 7 of 2016. Page number 1313, annexure number 2. This is writ petition number 72 of 2013, dated 30/4/2014. If I may take a lordship from page number 15. Have you got it, my lord, page number 15?
Yes, 15, yes.
I'll read from the second paragraph.
On consideration.
Above that, my lord.
On consideration.
I'll read from the paragraph, starting from the second paragraph. Mr. Solanet CGC submits that verification of the lands of the petitioners has already been done, along with other persons, and thereafter assessment is under process. He therefore submits that no further verification of lands is required as regards the lands of the petitioners. On consideration of the submissions made by the learned counsel appearing for the petitioners as well as the learned counsels appearing for the respondents, this writ petition is disposed of with the direction to the respondents to make a spot verification to ascertain whether the petitioners' lands are in the occupation of the army, paramilitary, Assam Rifles. The joint verification of the lands of the petitioners shall be done by a committee consisting of the following members. I'll skip this for a moment. Following page number 16. The Deputy Commissioner Lunglei District, Lunglei, Mizoram shall be the coordinating authority. The joint verification team so constituted shall verify the lands of the petitioners to be under the occupation of the Army, Assam Rifles, and shall thereafter furnish all details to the appropriate authorities for assessment, computation of the rental assessment, and payment thereafter. This exercise of conducting joint spot verification shall be completed within a period of 6 months from the date of receipt of copy of the order of this court by the DC Lunglei District. Thereafter, the process of assessment of the rental compensations should be completed within 2 months, and the respondents shall pay the said rental compensation to the petitioners within a period of 3 months thereafter, if their lands are found in occupation of the Army, paramilitary force, Assam Rifles. In the event the land of the petitioners have already been verified, as submitted by the learned CGC, no further spot verification will be required. However, the process of assessment and payment thereafter should be completed as expeditiously as possible and not later than 5 months from today. My Lord, this
So
order
if-
has not
if-
been appealed or reviewed. This has attained its finality, as it is, my Lord. And thereafter, if I may take your lordship to page number 18, the respondents have filed this IA seeking for extension of time for compliance of the order. Page number 18.
Extension granted?
Yes, my Lord. This IA is number 2 of 2015. This post on page number 19, 29-6.
Additional 6 months?
Yes, my Lord.
Okay. After that?
My Lord, your lordship, if I may draw your lordship kind attention on page number 21, my Lord. This application has been made only for the purpose of complying with the judgment order dated 30/4/2014 for compliance, my Lord.
Now they have taken a ground, they are not.
And my Lord, in the spot verification, my Lord, if I may take your lordship to the affidavit filed by the respondent number 5, affidavit dated 26/4/2016, wherein the verification report as well as the assessment was enclosed.
It was done, verification
It was done.
done.
And it was
Verification
held
done.
that it was inside the blueprint area.
And compensation was also.
Assessment was made. Assessment was made.
Assessment was made,
Payment was not done yet.
done. And now what the instruction shows us?
This instruction, my Lord, I have gone through once, and it appears that this is the
They have
case
not
pertaining
violated.
to different case, which is item number 4 listed today, contempt case number 3 of 2014. Even though they have marked both the contempt cases in the subject of this letter, but it pertains to
Acha,
the,
this is contempt 3 and 7 are, 7 is this one. And what is this contempt number 3? Contempt case number 3, that is a different case.
Different case.
But where same issues? Why are you clubbing 7 and 3 together?
Because the respondents are same, and more or less the issue is same regarding rental compensation.
Rental compensation, but same lands occupied by the forces.
It belong to the same district. The issue is same.
Acha, that this violated the Honorable Guwahati High Court order 3/3/2011. That was the same order that I've just read.
no, my Lord.
No, this is 2014 order. And what is this 3/3/2011 order?
That is the judgment order in connection
the
with the other
tree.
contempt.
Of 3.
Yes, my Lord.
but now you are taking a different stand altogether.
Lordship, let my learned friend complete their appraisal, Lordship.
So, my lord, at this stage, my lord, so far as this particular case is concerned, in spite of specific order passed by this honorable court on the last occasion to submit an instruction without fail, nothing has been submitted in this particular case.
You do one thing, Mr. KL, you file an affidavit bringing on record this.
Lordship, affidavit is there, I'll place before your Lordship.
No, this instruction?
No, Lordship, this is the latest instruction. Lordship may go through our affidavit. If Lordship found that there is a violation of the court's order, Lordship may pass any
Because
affidavit.
things are very clear.
Lordship.
It has to be assessed, first spot
Lordship,
verification,
the
whether the land is under the forces.
Yes, Lordship, that is problem lies. I'll demonstrate from my affidavit, Lordship. Lordship, consider everything, we have no objection, Lordship, if any order is passed.
No, of course, order is passed. Now the only question is you have to comply with the same.
Lordship, we have not violated the court's order. That I'll demonstrate from the order.
See, extension also you have taken for
No,
compliance.
Lordship, my learned friend complete. If he is completed,
Okay.
I'll.
Okay, fine. Then what else?
My lord, so far as my case is concerned, the order passed on 2014 was never appealed nor reviewed. It had attained its finality. And thereafter, in the year 2015, they have filed for extension
Wait,
of time for
The
compliance.
order is of 34/2014
Yes, my lord.
and then it attained finality. Only for extension they did.
Yes, my
Right?
lord.
No appeal.
29/6/2015, they were granted 6 weeks times for
They were
compliance, my
given
lord.
6 weeks times.
And in the verification report, my lord, it was found that it is within the blueprint area. And then thereafter, they have made an assessment. Even after making the assessment, my lord, they have not challenged the assessment also.
Yes, okay. So spot verification was already done. It is
Yes, my lord,
reflected
it was
in the order
accepted.
itself. So,
During the proceeding itself, my lord, the Rana CGC therein had
so it
accepted.
is in the blueprint area.
Yes,
That
my
is
lord.
a subtle thing. That is
Yes, my lord.
no dispute.
No dispute.
Then 6 months extension, 10.
And my lord, my humble prayer is that unless this order has been interfered with, this 2014 order, they have to comply with it. And
To comply with.
the manner
What
in
are
which
his,
they conducted, my lord,
What are his other affidavits?
they are filing affidavit by each and every incumbents on the same grounds. And the instruction letter which was submitted by my learned friend today is the same stand taken in those affidavit, my lord. Nothing new. This was heard by the coordinate bench of this court on several occasions, but we are still in this stage, my lord. So let your lordship pass an appropriate order.
Okay, you are finished. Let me hear what he says.
Subject to the submission made by my learned
Yes.
friend, I may
You will
allowed to
reply
make a
whatever
reply.
is
Yes, my lord.
required. Yes, Mr. Kya?
Lordship is taking 7 first, na? Contempt number 7.
Yes, 7. 3 is not before me.
Lordship, it is item number 4.
Oh, acha. Oh, that is item number 4.
Lordship.
Okay.
Lordship, my affidavit filed on 24. 24/7/2014, 24, by Ajay Kumar Bhala.
By Ajay Kumar.
Bhala. He was a Home Secretary at the relevant time.
Which respondent?
Lordship, now probably he is 15, because Lordship, in the meantime, most of the Home Secretaries are retired and new incumbent.
This is a recent affidavit.
This is a recent affidavit.
Date.
2014, you said. What is the date of your
24th July 2024.
24? I'm not getting it. 24 your. 2017 affidavit is the last. Is it in 3?
In lot 7, in both the contempt case, we file separate affidavits.
In both the applications there are.
Yes, Lordship. In both the cases, we file on the same day.
But these are all 2016, 17, 24 affidavit.
Lordship, my affidavit, Lordship, may.
Try to find out from here if you can get. Acha, 24 affidavit, yes. Is it additional affidavit?
This Lordship, yes, additional.
Additional affidavit, okay. By S1 number 11.
Ajay Kumar Phalal, page 2.
Haan, Jai Kumar, okay.
Lordship, in paragraph 3, we have stated about the different affidavits filed in the case. Then paragraph 3, 4.1. Married law.
Yes.
That the writ petition civil number 72 of 2013 filed by the petitioners was disposed of by this honorable court on 30th of April 2014 with direction to the respondents to do spot verification to ascertain whether the petitioners' land were in occupation of the army paramilitary forces / Assam Rifle. This exercise of conducting joint verification was also to be completed within period of 6 months from the date of the receipt of the copy of the order of the High Court by DC Lunglei. Therefore, the process of computation assessment of the rental compensation was to be completed within 2 months, and respondent was to pay the said rental compensation to the petitioner within a period of 3 months thereafter. If their lands were found in occupation of the army paramilitary forces, Assam Rifle pursuant to the direction of this honorable court, the government of Mizoram constituted joint verification committee by its order dated 21/5/2014. The meeting of JVC was conducted on 23rd July 2014. During the meeting, the representative of Ministry of Home Affairs raised the following objection. A. Presently, the claimed land of the petitioner were not under occupation of the security forces and it is outside the blueprint area. B. The defense state officer, Guwahati, should furnish a certificate as to whether the land were actually occupied by the security forces during the period from 66 to 86 or not. If the land of the petitioner were actually occupied during the said period, the security forces then joint verification should be conducted. C. Concerned authorities should verify whether these petitioners have not been paid said compensation for claim period earlier out of the fund released in the year 1995 and thereafter. Then
So what do you say is that these are not within the blueprint
yes,
area?
Yes, please to say annexure 1. This is the minutes of the joint verification committee. Lord.
So the lands are not under the occupation of security forces outside blueprint.
Yes, Lord, may please to see the annexure 1.
Of course, one of the rider in the
Yes.
order is that if only it is found within the
Within the
blueprint.
blueprint or occupied by the security forces during that period.
So your case is not.
Yes,
It is not occupied by forces.
Lord, may please to see the annexure 1. That will clarify everything. It is minutes dated 23rd July 2014. The meeting was convened by the Assis Manohara More, Deputy Commissioner Lunglei. All members of the representative were present in the meeting. The following points were discussed and considered. 1. Comments from representative of MHA. The following points were raised by the representative of MHA. 1. Presently, the claimed land of the petitioner are not under occupation of the security forces and it outside the blueprint area. B. The DO Guwahati should furnish all these things. 3 points, Lordship, I already read. Then Lordship,
Of course, this meeting is before extension of 6 months.
No, yes, Lord. Thereafter, Lordship.
Thereafter.
Lordship. Lordship is
That
to see
time
the
you did not know.
Lordship, see the order. The extension was granted to comply with the order. What was the direction in the court's order, Lordship? That is to be considered. And this is a contempt petition, Lordship, not a writ petition.
But
Lordship.
that time you did not know this land. Of course.
Yes, Lordship, because we are residing in Delhi and the state government has to verify all the things. Now, Lordship, may please to, I am allowed to read this. Then paragraph 2, comments of representative DO. The land of the petitioner of WPC 72 of 2020 fall outside the blueprint as demarcated during the security carried out by 19th of 13th June 2009. B. As per the board's proceeding dated 7th May 2005, the actual area occupied is 54,330 acres. However, the said sanction area listed under the sketch map 19th and 30th June are the which the rental compensation is only 36.18 acres. Then C, due to this variation, there is need to a redemarcate of the existing blueprint area and of the map prepared in 2009 by using high-tech equipments by ascertain whether the land actually.
What high-tech equipment? You want to verify on spot verification?
No, see
you
what
want?
happened. The area which has been recorded, it is not matching with the actual figure. Lordship. In paragraph 2B, Lordship,
As per board proceeding, dated so and
7th
so,
May
the
2005.
actual area occupied is so and so. Occupied by whom?
by the security forces.
However, as per sanctioned area listed
You
under
said sketch map.
area for which rental compensation is given for only
Only
this.
36.018.
There is a big difference.
Yes, Lordship. That's why Lordship DEO is proposed to.
But things are not very clear whether it is
No,
within
Lordship,
the.
Lordship, further Lordship will clarify everything. Verification of passage of the petitioner. The petitioner.
Wait, what is C? Due to this variation, there is a need to redemarcate
Remark the
the
existing
existing
blueprint area.
blueprint area of the map prepared in 2009 by using high-tech
High-tech
equipment
equipments.
to ascertain whether the land actually lies within the blueprint area.
Or no.
Then,
Lordship, 3, verification of passage of the petitioner. The petitioner produced passage issued by the then village council, Pukpui, during the year 1962, which was examined by all the members of the considered genuine. On further examination, it was found that the area of the land in the BC passage were much larger in area than the area claimed in the petition. The petitioners are contented that their claims were in accordance with the area and of the passage issued by the revenue. Then next paragraph 4, next page. On verification of the
hope
land
this
of
is
the.
properly revenue. After that, what? Hope the page is correct. Doesn't seem to end.
Lordship, seems like that.
It was found that the area of land in VC passes were much larger in area than the area claimed.
Was issued by the revenue.
The petitioners are content that their claims were made in accordance with the area pass issued by the revenue authority or something.
One
So
line is missing.
whatever they have claimed is lesser than the entire area, right?
Yes,
VC
yes,
pass.
yes, this is the case of the DEO. Now, Lordship,
Passes issued by the village council. So things are not clear. Spot verification is not done properly.
whether Lordship, this point can be raised in the contempt petition. Now Lordship has to see whether we have violated the court's order or not. And different, Lordship, I'll go further. Lordship will clarify everything. If required, Lordship, state is there because it was prepared by the deputy commissioner. So
By
they can
further
put-
discussion, physical verification of the land were considered not necessary.
not necessary on the ground, this is verification of the land of the petitioner, were considered not necessary on the ground that the verification was already conducted by previous joint verification teams and the land of the petitioner were included in the map prepared in 2009. B, the land of the petitioner are laying outside the blueprint area, that is the actual occupied area in 2009 and onwards, it is just adjacent to the blueprint area. Then C, the land actually occupied by the armed forces cannot be clearly ascertained for the period between 1966 to 86. It must, however, have been larger than the presently occupied area as shown in the map prepared in 2009. Moreover, it must have been affected by occupation of the neighboring land and access and use of the land would not have been possible at the point of time. Then conclusion, therefore, the member of the Additional Secretary Revenue and the Deputy Commissioner Longley on the verification of the team proposed payment of rental compensation to the petitioner for the period from 96 to 86. An assessment is prepared and as such other member of that is representative of Assam Rifle and DO of Guwahati do not agree with the payment of the rental compensation and they have submitted their comment at number 1 and 2 respectively, which I placed before your Lordship.
So 66 to 86 you are.
Yes, Lordship, they are claiming compensation when the insurgency problem was going on and the different land were occupied by the armed forces during the relevant period. And admittedly, Lordship, D, the petitioners are laying outside the blueprint area. It is admitted.
But then adjacent.
Yes, adjacent. Then Lordship may come to paragraph, subparagraph 2 of page 4 of the affidavit.
Do a proper spot verification. Things are not clear here.
No, Lordship, that's why we have the deputy
And then
commissioner.
in the new, this communication, you say that it was done without high-tech equipment.
Yes, Lordship, that was our prayer before the, and Lordship may please to see the other annexures. Then Lordship may come to next paragraph, subparagraph 2 of my affidavit, which I was reading. The paragraph 2, page 4. The representative of Defence State Officer, Guwahati, stated in JBC meeting that land of the petition falls outside the blueprint area map, and the land outside the said blueprint cannot be considered for payment of rental compensation. The DO of Guwahati, by its letter dated 14/10/2014, clarified that there is no record map of occupation of area before 1986, and the first such map of the area occupation was prepared in the year 1993. The blueprint map so prepared is the basis for payment of rental compensation of landowners, and the land outside the said blueprint cannot be considered for payment of rental compensation. It may also be pointed out that the verification report does not discuss any evidence, but merely presume that the land of the petitioner might have been occupied. Such vague presumption cannot settle an individual for payment of rental compensation. The DEO, Guwahati, also sent a copy of clarification to the Principal Secretary, Land Revenue, Government of Mizoram. Paragraph 3. That based on DEO's clarification, Government of Mizoram was inter alia informed by letter dated 10/12/2014, stating that the land of the petitioner fall outside the blueprint area, and hence claim could not be considered for payment. The state government was requested to take further action to address the issue raised by the representative of Ministry of Home Affairs and DO Guwahati, and also appraise the Honorable Court in the matter. Lordship may please to see 10 December letter, this Annexure 2 to the affidavit. Married Lordship. The letter dated 10 December 2014. It was written to the Revenue Secretary by the Ministry of Home Affairs, Lordship, in response to state government of
But then
Mizoram.
you see, at one point of time, you say that it falls outside.
Yes, Lordship.
But again, you have said in paragraph 2 that verification report does not discuss any evidence,
See-
but it merely presumes that the land of petitioner might have been occupied.
Lordship, verification is before your Lordship. Lordship may please to see whether there is any evidence or not. We try to explain that how the assessment was made. The Lordship may please to see the letter written to the Ministry of, to the state government.
This one, Annexure 2.
Yes, Annexure 2. It's a letter dated 10 December 2024, written by the Home Ministry to the Revenue Secretary, Mizoram. In response to state government Mizoram letter dated so-and-so, enclosing herewith clarification given to settlement officer and Ministry of minutes of the joint verification team meeting held on 23/7/2014, as well as the assessment of rental compensation amounting to rupees 1 crore so-and-so. In the above cited subject, the attention of the state government is drawn to the ministry's endorsement, event number dated so-and-so. Paragraph 2. In this regard, attention is also invited to the minutes of the meeting held on 23/7/2014, in which the MHA representative has raised the following points. 1. Presently, the claimed land of the petitioner are not under occupation of the security forces and is outside the blueprint area. B. The DO Guwahati should furnish a certificate as to whether their land were actually occupied by the security forces during the period from 1966 to 86 or not. If the land of the petitioners were actually occupied during the said period by security forces, then spot joint verification should be conducted. C. Concerned authorities should verify whether these petitioners have not been paid and said compensation for claim period earlier out of the fund the year 1995 and thereafter. 3. Comments of the representative of DO that the land of the petitioner in WPC number 72 of 2013 fall outside the blueprint area as demarcated during the survey carried out between 19th and 30th June
If
2009.
you knew all this, then why not you placed it during the writ proceedings?
Lordship, these are subsequent development, Lordship.
But 2009 only you knew.
No, Lordship.
Those,
That was, Lordship may see the letter dated 2024. And Lordship, the order was passed.
this is a letter in 2014,
No, the writ petition was disposed of
2024. Oh,
No, no.
14.
2014.
April. This is December.
Yes, Lordship. Then Lordship,
Now your case is that it doesn't fall within blueprint area and not.
and we have not violated the court's order. This is our submission.
Yes, because that had a rider.
Yes,
But
ma'am.
then I'll have to see whether you had the knowledge when the.
No, Lordship, please to see the direction of the Honorable Court and the steps taken by the state government as well as by the Ministry of Home Affairs. We put our objection to the verification on the spot, Lordship. That their land is outside the blueprint area. In spite of that, Lordship, assessment was made, it was sent to the ministry.
Acha, can we do one thing? I'll go through all this, then you are here, day after tomorrow I can take it up.
Lordship, I am leaving tomorrow, Lordship.
Or tomorrow we can take it up. Tomorrow you are here?
Yes, my flight is at 3:30.
Okay. We'll take it up tomorrow. Let me go through all the
Lots.
affidavits. I'm not very well, so I couldn't.
And in item number 4,
Huh.
we have also filed affidavit and we have clarified every portion, Lordship.
Item number, the other one.
4.
Same affidavit?
No,
Or what?
Lordship, affidavit is different, Lordship. But on the file on the same day.
Of course, one thing you have, that had the order has a rider, that
Yes.
only when it is in the blueprint. But what do you say on this? But I will look into the entire files, but what
Yes,
do
my
you
lord.
say?
In fact, my lord, the application for extension was filed on 2015.
That we can see.
And
Till then, they did not have the information.
all the documents he relied upon was on the basis of 2014 letter, 14 letter.
And spot verification, when was it done? Date?
It was done on 23rd July 2024. Annexure 1.
24, after.
Yes. No, Lordship, 14.
14 years.
My lord, this court, on last occasion, on 26 September 2023, in this contempt proceeding, we had already this lengthy hearing, and if your lordship may kindly turn to order dated 26/9/2023.
Order
Yes, my lord, 26/9/2023.
26/9/2023. Yes.
I'm referring this to show that instead of going through all the details affidavit, my lord, everything, all the relevant portion are reproduced in this order.
Lordship, on 23rd 10/2024, this Honorable Court heard the matter and passed this order. And in this case, Lordship, everything is recorded, the submission of the petitioner as well as
Which date you said?
23/10/24, in both the cases. May I submit the copy of the
23/10/24.
Lordship. Probably it may not reflect in the order,
It is there.
but it was pronounced after.
It was kept as CAB for,
Yes, it was kept CAB. But if this is the order, that's why this Honorable Court, in both the cases.
Then what happened? For final, immediately thereafter is for final hearing. Thereafter what happened?
Lordship, then Lordship, this Honorable Court thinks fit to call for some report from the state government, but they didn't. But probably that is not required because all the documents are available in the record. So I have placed the order passed by this Honorable Court on 23/10/2024 in both the cases. In paragraph 10, my submission is recorded And this is basically our case.
This is there in the orders.
Yes, ma'am.
This is what? The first one is what?
There are two orders in two different, different cases.
This is 2310.
Yes.
2310 is there in the records. And this is
Both on the same date.
1 in 3 and 1 in 7.
Yes, yes.
It's okay, I have this in the records. So what do you say on this? You have said that while extending the order, they have not placed all this.
My Lord, in order to appreciate the query raised by your Lordship, my Lord, if I may take your Lordship back to the extension order, my Lord, in my contempt petition, page number 19. It's a short order, if I may be allowed to read the entire
19.
page number 19 of my contempt petition, 19. Order dated 29/6/2015. Heard Ms. Solange CGC, who submits that a further 6 weeks time may be given to the applicants to complete the process of verification and to comply with the judgment order dated such and such. The further prayer of Solange CGC is that a direction should be issued to the state government to rectify the objections raised by the representative of Ministry of Home Affairs. Mrs. CGC submits that the rectification of objections is necessary inasmuch as the landowners have been converting the land pass into a PD Pata in 2006 for the purpose of claiming land compensation. She submits that this is bad in law and cannot be allowed. The question of converting the land passes into PD Pata is not barred under any law, unless the same is barred by law or land acquisition laws, for which a prior necessary notification has to be issued by the competent authority before acquisition of land. The applicants CTC have not produced any law or rule which bars the conversion of pass into PD Pata while it is occupied by a person other than the landholder. The present case relates to verification of land for the payment of rent only. In any event, the submission of the land CGC with regard to the subsequent conversion of land pass into PD Pata cannot be a subject that can be dealt with in this application. As such, the prayer of the land CGC with regard to giving a direction to the government of Mizoram to rectify the objection raised by the Ministry of Home Affairs cannot be considered and allowed by way of this interlocutory application, as this is an internal matter between the applicants and the state government. With regard to the prayer for additional 6 months' time to comply with the order passed in WPC number such and such, Mrs. So-and-so, learned counsel for the private respondents, and Mr. So-and-so, learned additional AG, do not have any objection to the same. The order dated has observed as follows. In the event the lands of the petitioners have already been verified, as submitted by the learned CGC, no further spot verification will be required. However, the process of assessment and payment thereafter should be completed as expeditiously as possible and not later than 5 months from today.
Actually, no further spot verification was ordered.
Yes, my lord.
Verification was already done.
Correct, my lord.
Because in the event of the lands of the has already been verified, as submitted by CGSC, no further spot verification.
Correct,
required.
my lord.
Of course, in the event that it has been verified. Then,
Further, letter dated 38/2014 issued by the settlement officer, Lunglei District, state as follows. In compliance with government order via letter number 21/5/2014, a meeting of joint verification team to conduct verification of the lands of the petitioners under the WPC was held on 23rd July 2014 at 3 p.m. Meeting minutes duly signed by all the members of joint verification team except representative of DEO Guwahati Circle, with assessment of rental compensation to be paid to the landholders by Ministry of Home Affairs is forwarded herewith for favor of further necessary action. Thereafter, a meeting of the joint verification team, which was held on 23/7/2014, and in pursuance to the same, assessment of rental compensation payable to the petitioner was made. Counsel for the private respondent submits that there is no requirement for a fresh verification in view
and
of the above.
where is this joint verification team's meeting?
This is, I'll come to that later, my lord. My lord, friend, just refer to this.
That Annexure 1?
Yes, my lord.
July, 23rd July, yes.
23rd July 2014. And this,
in pursuance to that, assessment is made.
yes, my lord. And in pursuance to that, they have filed this application, extension application for compliance. May I continue? This application has been made only for the purpose of complying with the judgment order dated 30/4/2014. Additionally, an additional 6 months time with effect from today, as rate is granted to the applicants to comply with the order, so and so. My lord, that verification team meeting minute, my lord, the conclusion amongst others was that the admitted position is that, my lord, the occupied area has been reduced from time to time. And until this 2009 blueprint was prepared, it was always inside the blueprint area. And it was also observed and undisputed that it lies just adjacent to the existing blueprint area. So there's no dispute about the occupation of the petitioner's land, my lord. But now, my lord, instead of filing an appeal or a review or whatever as deemed to be appropriate, they're taking this stance at this stage to circumvent the direction of this honorable court, my lord. The petitioners here, only 3 of them were suffering. They have been deprived of their land. And the assessment also is not that big money, my lord. It's only between 1967 to 1986, and the total assessment amount is only rupees 1 crore plus.
That will not be an issue whether you are entitled, that is the thing. Okay, let me take it up tomorrow. I'll go through all the
Please, madam.
records here.
May I please one judgment in support of my contention, Lordship? Paragraph 9, 10 and 13 of this. I've written on the top of the judgment. This is a printout of Supreme today.
Okay, I'll go through.
Lordship, tomorrow
This is on
matter may be
contempt.
taken as item number 1 and 2. Lordship.
Yes?
Tomorrow matter may be taken as item number 1 and 2.
Okay, we'll take it up.
Lordship, much of
If I may, Your Lordship, may I just make one small submission in item number 4,
4.
the connected case. It's because this is slightly, although it relates to the same area, and the issue is again rental compensation, the manner in which the verification was conducted and what they have submitted in this particular contempt proceedings is slightly different. Now, and also I would like to...
Instruction relates to both the matters.
Yes, Lordship.
This particular instruction, I believe it more relates to the present item number 4. Now, out here, Your Lordship, I've glanced through it. It was since it was handed over just now. I've glanced through it, and from what appears to be their statement is that our lands were not found in occupation. Number 1, it was outside the blueprint area, and number 3 is that they did not use any high-tech equipments while taking the verification. If Your Lordship, I will just mention the name since Your Lordship will be going through the affidavits anyways. This is one affidavit of Sasindram CK, 2 IC Assam Rifles. This
It was filed in item number 4.
item 4. Sasindram CK, 2 IC 28 Assam Rifles. This was submitted on 27th of June 2014. And it is exactly the same thing. In this affidavit, this so-called clarification was already incorporated. So this, what they're stating in this particular so-called instruction is nothing new. At the outset, Your Lordship, in my case, what I would like to mention is that the issue of whether the lands of the petitioners was inside or outside the blueprint area was already handled by this Honorable Court in the writ proceedings.
In the same order.
In the same order.
30th of April.
Yes, no, this is 3/3/2011.
Or in your matter.
In my matter. Because that was the stand taken by them in the writ petition itself. So this court was of the opinion that nothing doing, whether it's inside or outside. If it is found to be under occupation, you have to pay. That's it. So the issue of whether it's inside or outside the blueprint area is no longer res integra.
But if it is under occupation of the forces,
Yes, then you have to pay. Forget the blueprint. That's what
there is a difference between...
No, the so-called blueprint which they keep talking about cannot be relied upon. The reason being is that, Your Lordship, during the period of assessment is from 66 to 86. That is the period of insurgency. Thereafter, after the state of Mizoram attained statehood, there was a meeting between the Ministry of Home Affairs and the government of Mizoram because their requirement for land had considerably reduced. So this so-called blueprint area was first prepared in 91-92. Again, that was redrawn again in 2009. So how can you say that I am inside or outside the blueprint area when the period that we're concerned was before the blueprint, so-called blueprint map was ever prepared? That is number one, Your Lordship. And number two is that if Your Lordship can kindly turn to my contempt petition.
Yes.
Page 39 of my contempt petition is the meeting minutes. After, in this meeting, the verification,
Which page?
page 39, annexure 5. This is contempt number 3 of 2014.
Page number?
39, 39.
Yes.
In this meeting, Your Lordship, the verification report was placed and was considered and was accepted. At serial number 1 at the bottom, Your Lordship, if I may read. The joint team of officers had approved the map of Army paramilitary forces occupied area at Komzol as duly countersigned by Major P.S. Gill, representative of 40th Assam Rifles Battalion, N.R. Das, representative of DEO, this is Defense State Officer, Guwahati. They are the concerned office responsible for all lands occupied by their security forces, and Colonel V.N. Kulkarni, representative so-and-so. It was decided to conduct spot verification of the occupation of private lands based on this approved map. So, the verification number 1 was conducted on the basis of a map duly approved by them. It is not a map prepared by the state government or the petitioners.
Yes, that is an approved map.
Yes. So that is number 1. Thereafter, then you have sub-serial number A, B, C. These are the names of the petitioners. So, detailing the manner in which my lands are occupied. And lastly, at page 44, Your Lordship, this is the attendance sheet. This is the attendance sheet of the meeting minutes. If Your Lordship can kindly look at serial number 3, 4, and 5. They had duly signed this, approved it. Verification was done on the basis of a map approved by them. Spot verification was placed before them, approved by them, duly signed by them. Now, whether this same issue can be raised in a
this shows that it is within the occupation of the forces.
It is within the occupation. There is no question of blueprint or not. There is no question on that. And thereafter, at page
According to you, blueprint had come later, 91-92.
91-92. For that matter, Your Lordship, the judgment and order which we are that we're relying on at page 22, annexure 2. This is the judgment and order passed in the writ proceedings. And at page 31, at para 10, this facts was also clearly stated without rebuttal.
Justice Michael was then the advocate.
Yes, so it's a long time now. He's close to retiring also.
And then things are still pending.
Yes, Your Lordship. 1, 2, 3, 4. Fifth line from the top of para 10, it says blueprint area prepared in 92-93. Now, at the next page, at page 11, this is the direction, Your Lordship. The direction is that, taking note of the facts involved in this writ petition, the contention of the respondents in their counter affidavit and minutes recorded in para 3.4 of the meeting held on so-and-so, in particular, this court finds it reasonable to and appropriate to direct constitution of a joint verification team for re-verification of the lands of the petitioners, whether such lands fall under the occupation of the armed forces or not. Mr. So-and-so and CGC so-and-so agreed to with the joint team of officers directed to be constituted by this court while disposing WPC number so-and-so by order dated so-and-so. The joint team so constituted shall make spot verification in respect of the lands of the petitioner herein and to ascertain whether the lands are under occupation of army or not. While making spot verification, all the petitioners shall remain present with their land documents. Such verification shall be completed within a period of 3 months from the date of receipt of a copy of this judgment in order, if the petitioner's lands during spot verification are found in occupation of the army, respondent authorities shall take steps for payment of rental compensation and from the date of occupation. So the direction is clear. If the team finds that your land is under occupation, you have to pay. There is no question of blueprint or no blueprint. And another reason why...
What is the distinction between blueprint and occupation of forces?
Your Lordship,
According to you, blueprint came later. Then
no, blueprint area in 1992 was prepared to ascertain the lands which the security forces will continue to occupy after the insurgency. So this blueprint area only demarcates the land which they will continue to occupy in the future. So that is the only thing. So, and so that's why at number one is that, Your Lordship, no appeal has been preferred by them. Now the reason why I had...
in this case, any extension?
No extension. Now the reason why I had brought to Your Lordship's notice that affidavit dated 27/6/2014 is that verification...
Which affidavit?
That affidavit of Sasindran C.K.
Affidavit
of 2IC Assam Rifle.
now by respondent number?
It's not written because there are so many incumbents who were, we kept pleading them.
Who filed? Who sworn? Who had?
The MHA filed in the name of one officer, Sasindram C.K. Date of the affidavit is 27/6/2014.
Dated?
27/6/2014. It's not a very thick affidavit.
2014.
Yes, Your Lordship.
June, right?
June.
Yes, I got it.
So in this affidavit, I will not go through the entire thing. This is, like I had stated earlier, basically this is the statement, basically reproduction of what they have stated in the newest, latest instructions. So what I'm trying to impress upon Your Lordship is that in
Where
this,
is that? The same things that they have stated?
it's more or less the same. The high ten, they
Which
did not.
paragraph? Joint team of staff did not approve the lands of the beyond blueprint area. Okay. Paragraph A.
Yes. So, for example, at para C, in reply to para 10 of the contempt petition and
High-tech.
high-tech equipment. So
Was
it basically is a reproduction, the same thing.
things.
So what I am, the reason why I am highlighting this and what I'm trying to impress upon Your Lordship is that in 2000, the verification was conducted in 2013, March. We filed the contempt petition in 2014. They filed this reply in 2014 itself. They're saying that because of A, B, C, D reasons, whatever reasons, something's wrong with the verification report. But they have not challenged that verification report till date.
Where is the 2013 verification report?
I just read out that
Oh, yes. In your petition.
in my petition at page number 39.
Acha, that is before your writ petition.
No, this is after my writ petition was disposed in 2011. Verification was finally conducted in 2013. And since they did not take any steps, even despite of this verification report.
Before the order of 2014, this verification?
2014, which order, Your Lordship?
No, the one you have challenged. No, in this order, this is 2013.
11.
Oh, 11. In his application.
Yes, his contempt petition is maybe 14.
Yes.
Out here is 2011. Verification report is 2013. We filed the contempt in 2014. And they submitted this affidavit in 2014. What I'm trying to impress upon your lordship is that if they had any issue with the manner in which verification was done, they could have challenged the joint verification report before this honorable court by way of filing a writ.
They have not challenged.
They have not challenged that. And the records clearly showed that verification was done based on a map approved by them. They approved the verification report. They signed on it. Now how can they say that they're not liable and we're having a problem with ABCD? I've given one order already passed by this honorable court, quite a lengthy order. Again, this was also passed by Justice Vaipe, the former Chief Justice of Tripura. This is order dated 29/8/2014. I've taken the liberty of printing it out.
Yes.
At relevant paragraph is at para 11, Your Lordship. Your Lordship has it? May I read?
In K. Ansari?
Yes, may I read, Your Lordship? In K. Ansari and Nader versus Indian Airlines Limited, the Apex Court observed that difficulty in implementation of court's order, howsoever grave its effect may be, is no answer to its implementation. If there was any doubt or if the order was not clear, it was open to the officials to approach the court for clarification. Without challenging the said direction or seeking clarification, authorities could not circumvent the same on any ground whatsoever. Again, in Prithwinath Ram versus State of Jharkhand, the Apex Court held that while dealing with an application for contempt, the court is really concerned with the question whether the earlier decision which has received its finality had been complied with or not. It would not be possible for a court to examine the correctness of the earlier decision which had not been assailed and to take a view different than what was taken in the earlier decision. If any party aggrieved by the order which in its opinion is wrong or against the rules or its implementation is neither practical or nor feasible, it should approach the court which has passed the order or invoke the jurisdiction of the appellate court. Rightness or wrongness of the order cannot be urged in contempt proceedings. Right or wrong, the order has to be obeyed. Flouting an order would render the party liable for contempt. While dealing with an application for contempt, the court cannot traverse beyond the order, non-compliance with which it is alleged. It cannot test the correctness or otherwise of the order or give an additional direction or delete any direction. That would be exercising review jurisdiction while dealing with an application for initiation of a contempt proceeding. The same would be impermissible and indefensible.
Okay.
So the principles have been clearly laid out.
This is a subtle position of law.
Yes, Your Lordship, but then my learned friends have, since 2014, they have been raising all these grounds on merit.
You have already jotted down those in 2014 affidavit. Now again the same.
So, again, Your Lordship, this is nothing more than a dilatory tactic, Your
You
Lordship.
do one thing, why don't your counsels give me one small written argument? I can dispose of this matter.
Lordship, in this case, that order placed by learned friend that was challenged in the appeal before the Honorable Guwahati High Court.
The 2011 order is challenged?
Yes, Lordship, it was challenged then because Lordship, here personal appearance of the Home Secretary was given.
My learned friend is talking about the order passed in the contempt.
Yes. In
Contempt order,
yes.
not the judgment.
Oh, not the contempt order is okay.
Yes.
Judgment have better.
No, Lordship, regarding proposition of the law, we have no quarrel, Lordship.
As far as the judgment in 2011, there is no appeal.
No, Lordship,
That had attained finality.
Yes, Lordship, we have complied with the order.
How?
Lordship, may please to see my affidavit in this case, Lordship. File on 24/7/2024. Page 3.
Wait, a file on?
The entire facts has not been placed before our Lordship. This is the problem.
Which affidavit?
Filed by Ajit Bhala, Lordship. Ajay Kumar Bhala.
In item number 4, right?
Yes, Lordship.
What is the date?
Lordship, 24/7/2024.
24/7/24.
In both the cases on the same day, 2 affidavits have been filed. By Ajay Kumar Bhala.
Acha, additional affidavit.
Yes, Lord, additional affidavit.
Wait,
Lordship, may directly come to page 3.
page 3.
Lordship.
Wait.
Married, Lordship. The 29 petitioners had filed WPC 60.
Where? Page number?
Page number 3.
Yes.
Married, Lordship.
Yes.
that 29 petitioner has filed WPC 62 of 2007 in the Honorable Guwahati High Court for non-payment of rental compensation for occupation of their land by the armed forces since 1966. By the judgment and order dated 7 January 2009, this Honorable Court issued direction to constitute joint verification team to verify the land of the petitioners. 2. That the Commissioner and Secretary to the Government of Mizoram issued order to constitute a task force comprising of the officials of the Ministry of Home Affairs, Ministry of Defence and State Government to conduct spot verification on occupation of the land of the petitioner by the security forces at Kaujamal, Longley, and list of the petitioners for rental charges and make the computation. 3. That during the spot verification, the joint verification team of the task force did not approve the land of the petitioners, which was beyond the blueprint area prepared in 1992-93. Only the land of 3 petitioners out of 29 petitions was approved, being agreed by the decision of this joint team, WPC number 8 of 2010, against which the present contempt petition has been pending, was filed by Sri Lal Sanghiana and 24 others against the Union of India for in February 2010 at Guwahati High Court, Aizawl Bench, praying for constitution of joint verification team to verify the land outside the blueprint area made in 1992-93. That on 2nd May 2013, joint verification team, joint verification was carried out without high-tech equipment. It was constituted as spot verification as per the earlier map approved. Minutes of the meeting were prepared by the district civil administration and not even consulted with the representative of MHA and Assam Rifle, who was part of the verification team. The document recommendation as mentioned in the minutes were not discussed and were prepared and forwarded to the higher headquarters by them with attendance sheet instead of signed copy.
These are internal, this cannot be, again, the petitioners will not be affected by this.
Lordship, may I please to see Annexure 1. This is the minutes of the meeting of the joint verification team.
This one only he had placed just now. Yeah, he had placed
Only
this.
attendance sheet is there, Lordship.
Huh?
Only attendance sheet was annexed, Lordship. No discussion was there. Then, Lordship, next annexure. It is a letter written by the Home Ministry to the Deputy Secretary, Revenue, Mizoram Government. The letter will clarify everything, Lordship. Annexure 2. It is a letter dated 26 June 2013. In response to your letter dated so-and-so on the, Lordship got
ये ठंडा हो गया.
married, Lordship.
Yes, Annexure 2.
It is the letter dated 26 June 2013.
Yes.
In response to your letter dated 11/6/2013.
You don't have to read the entire thing.
Lordship, this is the Lordship, last paragraph, paragraph 3. In the above background, the state government is requested to verify the claim accordingly and forward the same after verification by the concerned quarter inter alia, certifying that these individuals have not been paid rental compensation out of the amount released by the government in 1995 and thereafter pursuant to the High Court's direction. It is requested that the petition in respect of all the petitioners should be also be mentioned. Then let's see next annexure. Let's see annexure 5 may kindly be seen.
Yes.
How the things moved. Letter dated 19/6/2016. Minutes of the meeting held on 19/9/2016 under the Special Secretary, Internal Secretary MHA on the issue of contempt case number 3 of 2014 arising out of writ petition number 8 of 2010 between so and so, other related to the land compensation. Meeting was attended by following persons. Then in the meeting, brief of the case was discussed and the following decision was taken. 1. Secretary Revenue Government of Mizoram pointed out that the land ownership documents produced by the petitioners were issued in Mizoram only in 1989 with prospective effect. Before 1989, Village Council used to issue Village Council passes which have been held invalid for the land compensation by the Guwahati High Court, and the Guwahati High Court confirmed a single bench order of the High Judge Bench Guwahati High Court. 2. Representative of DG Assam Rifle mentioned that the period of limitation for central compensation was valid for up to 30 years, which expires in September 2016. If this case comes for hearing, how we can bring this into the notice of the concerned court? Regarding this case, it was decided that the Government of India has sent a detailed communication to the Government of Mizoram on 8/9/2016. Accordingly to the Secretary Revenue, this matter will be examined expeditiously. The facts will be brought to the notice whenever a notice of contempt is issued. Then in view of the facts mentioned above, at this moment no payment is due from the Government of India to any of the claimant if the writ petition, then the matter will be examined based on consideration response of the Government of Mizoram.
Okay,
It
let
is
me
n-
go through.
It is not the case that we are not paying compensation. Lordship, the person who has found to be genuinely, his land has been occupied by the armed forces, compensation payment,
No,
Lordship.
let me go through all the
Till date,
affidavits,
Lordship,
then-
150 crores has been paid to different petitioners, Lordship.
What transpires from my learned friend's submission? Two things. They have not denied occupation. They are only saying that it's outside the blueprint. Number one. Number two is that the letter which he has just read out, without assailing the directions of this honorable court, whether such an administrative decision can bypass the judicial decision. That is administrative overreach.
They have denied compensation on the ground it doesn't fall within the blueprint area. This is what.
Yes, that is, and they haven't denied
Let me
occupation.
go through, tomorrow we will take it up.
Yes, Your Lordship.
And just try to prepare one written argument.
I'll try.
There are so many affidavits on
Yes, sir.
saying what is relevant and what is
Yes,
not. As prayed for by the parties, list the matter tomorrow.
Obliged, Your Lordship.
Item 5.
These are also there. Yes.
May it please Your Lordship? This contempt case is filed against the respondents for their disobedience for not complying with this honorable court's judgment in WPC 148 of 2019, the order dated 19 March 2020, my lord, wherein this honorable court issued direction to the respondent number 3 to constitute a verification team, which the respondent number 3 accordingly did, and then to the constitution team to be constituted will be consisting of the
I think the problem is that periodic passes, right?
yes, my lord.
Wait, I am not able to get your contempt application. Additional affidavit, show cause. Yes.
Yes. The operative portion is at page number 13, my lord, of my contempt petition.
13, yes.
Page 13, last paragraph. In view, may I read?
Yes,
Yes.
I've got it.
In view of the consent of the parties, this court is of the view that a verification team should be constituted. Accordingly, the Secretary to the Government of Mizoram Land Revenue and Settlement Department shall constitute a verification team consisting of the district collector, come deputy commissioner, Kolasip or his representatives, the deputy chief engineer, construction, NF Railway, Silchar, Qatar, Assam or his representative, and the petitioner who shall verify the lands of the petitioner within a period of 1 month from the date of receipt of a copy of this order. The verification team consisting of the above persons shall verify whether the lands of the petitioner have been in use by the respondent number 2 for constructing a road. If the answer is
The service is not complete.
completed, my lord, respondent number 1, 3 and 2 have also filed their show cause reply, my lord.
Today they are not there. Today none of the counsels for the respondents are there. In fact, who had appeared on the last occasion?
Respondent number 1 and 3 has been represented by Mrs. H.L. Swami. Respondent number 2 has been, there was a new incumbent which was impleaded as respondent number 5 in place of the respondent number 2, which was represented by Ms. Zairam Sampui and Mr. Mehdi.
Zairam Sampui, you are there? You are there for which?
My lord, I already filed my affidavit for respondent number 5 on 27 September 2024.
So you are only for respondent number 5?
My lord, thereafter, my learned friend Sanjay Mehdi filed wakalat nama. I don't know whether I will still representing or not.
Who, for whom? Respondent number?
I filed for respondent number 5.
And who else are you representing? You are not sure? There are more respondents after 5.
No, my lord. It seems Mr. Sanjay Mehdi again filed his vakalanama in favor of the respondent number 5 after Ms. Zairam Sampui has already filed her show cause. So,
Same respondent.
yes, my lord. It is only upon the respondent number 5 to comply with the court's direction, my lord. Assessment was already done by the respondents 1 and 2, my lord, and accordingly, amount has also been made, which was to be compensated to the petitioner, my
the
lord.
funds were arranged. Only it has to be disbursed.
Yes, my lord.
That disbursing thing is not done.
No, the respondent number 5 is to make the necessary arrangements for the funds, which he has not done till date.
So the main respondent is 5.
Yes, my lord.
5 is
The
this,
chief engineer, my
Northeast
lord.
Frontier Railway chief engineer.
Yes, my lord.
Okay.
The
So
deputy chief
what do you say,
engineer.
Ms. Zairam Sampui?
My lord,
SK Mehdi has filed his wakalatnama on 24/2. The same is annexed to his additional affidavit.
my
Filed
lord,
on behalf.
as far as my understanding, if he filed wakalat nama against me, then he will be representing the matter later on.
But you have to give no objection, otherwise how can you file an wakalatnama?
I don't know.
Anyway, affidavit is by whom? Affidavit by respondent number 5 is filed.
Yes, my lord.
Yes, my lord.
And 1, 2, 3, 4, nobody represented from day 1.
1 and 3 were the necessary parties, my lord, so they have already filed their show cause and
Today they are not there.
represented by Mrs. H.L. Swami, my lord. They have already complied with the court's direction, my lord.
Regarding the first 2 part.
Yes, my lord.
Now only the disbursing is left.
Yes,
And
my lord.
arranging the funds.
Yes, my lord.
And as far as that part is concerned, you have stated in your affidavit, disbursing and all, arranging funds. Where is your affidavit?
My affidavit was filed on 27 September.
This is show cause reply in the form of an affidavit by respondent number 1. Not required, right? Respondent number 5 is there. So what do you say on this, arranging funds and all? Perhaps you are not prepared, then we'll go through the matter, we will take it up on a later date. Okay.
Then in the meantime, I'll get instruction regarding which will be.
Who will be appearing?
Yeah, yes, my lord.
You right. Heard Miss
Valentina Aldinpuye.
Valentina.
Yes, my lord.
Acha. Heard Miss So-and-so for the petitioners, and Miss Zairang Sangpui.
For respondent number 5.
Now that is also not very sure, right? For respondent number 5.
Yeah, right.
And, oh yes, Miss So-and-so for the petitioner submits that the present contempt petition, submits that as far as the direction in the present contempt petition is concerned, the first 2 directions were complied with. However, arranging of funds by respondent number 5 as well as thereafter disbursing is left. Right. These were the directions.
Yes, my lord.
Disbursing is left to be complied with as per the directions in the order dated 19th of March 2020. Yes. When the matter is taken up today, Ms. Zairang Sangpui, however, submits that another counsel has filed the wakalatnama to appear on behalf of respondent number 5, and as such, she needs some time to clarify on the same issue. Prayer is allowed. List this matter on after 2 weeks or after a week, whatever you say.
After a week, my lord. It has been pending for so long.
Yes. So list this matter on this one. Then 20, this is 8, right? And then on 24th
My lord.
or 23rd of September.
24th is DB day, my lord.
Okay. So okay then 23rd.
My lord.
23rd of September 2025.
Much obliged.
Obliged.
Item 6.
May I please?
Yes.
My lord, I am appearing in this matter on behalf of respondent numbers 6 and 7, Lordship.
Can you
Lordship, we are seeking some more time, Lordship. Can it be after 3
reduce
weeks?
the volume a little? Yes. This is for Jimma of some cash amount.
Lordship. Because it was handed over to the income tax department, my lord, pursuant to my lord recovery. And my lord, they have filed a Zimma earlier, it was rejected, and against that they have come up before your lordships. So, my lord, some instructions are still awaited, lordship. May I pray, my lord, at least 2 weeks time may be granted.
Respondent number?
6 and 7, my lord. That is income tax department.
You are for 6 and 7. So money
Lordship.
is where? Money is?
Money is with the department, my lord.
Okay, you need some time to get some instructions. On what?
Lordship, I need
On
some
what?
time, further time.
What instructions you want?
My lord, some proceedings has been drawn against my lord, the petitioner, my lord. What was the stays all about that, my lord? Because, my lord, though they are claiming exemption, my lord, however, my lord, they are subjected to certain, my lord, conditions, my lord. No blanket exemption is not there, my lord, under the provisions of Income Tax Act, lord.
No, that is a different issue. This is only custody.
Lordship.
Ambalal Desai, the Supreme Court says that even cash amount during the proceeding should be handed over.
My lord, otherwise, my lord, we are saying, my lord, that amount what was there, my lord, what was recovered, my lord, that does not belong to the petitioner, my lord. And in fact, my lord, that is not from, my lord, the genuine source of income, my lord.
Okay, you
I
get
mean,
the
at least 2
instruction
weeks,
then.
my lord. I am praying for.
Heard Mr. S. Setia, right?
Lordship,
S. Setia,
lordship.
Learned Counsel for the respondent number 6 and 7. Yes, Mister, he wants to get some instruction. The money does not belong to
Yes, your lordship.
so and
Yes.
so. Who prays that he may be given some time to get the instruction from the department. Prayer is allowed. Yes, Miss Mary, let him get the instruction. Yes, okay. The prayer is not objected to by the counsels appearing for petitioner and respondent. List this matter. When do you want?
Lord, let it be on 26th
Before vacation,
of
Your Lordship.
Huh?
If it is possible, before vacation.
Yes, so
26th, Lordship.
26th is a Friday. Okay. 26th of September. Okay.
Lordship.
Oblige.
26th of September.
Oblige.
2025.
Item numbers 7 to 12.
So many. I think there is a compliance, right, to this?
My lord, I'm seeking another some more time for compliance of
But
the
then
court.
compliance affidavit you have
My
filed,
lord,
I
as
think.
the coordinate bench of this court pass some order
On which
in
date?
some other similar cases, and the matter listed on 7/10/2025. Then same order may be passed in this regard.
There are similar
Yeah,
matters,
similar
analogous.
awards for making payment of
Those are filed
compensation.
on, those are fixed on 7/10.
Yes, my lord. All cases are under same award now.
What do you say on this? Say similar matters I'm told.
No objection.
I heard Ms. Zairang Sangkui for respondent number.
For respondent number 3, 7 and 9.
3, 7 and 9. Ms. Zairang Sangkui presents or places an order dated 2/9/2025 in respect of analogous petitions.
Yes.
Analogous.
In respect of analogous petitions, and by the said order, the said matters are fixed on 7/10/2025. And as such, a prayer is made that the instant matters may also be listed along with the contempt application number 25 of 2019. Prayer is allowed. List this matter on 7/10/2025.
Oblige.
Item numbers 13 to 16.
My lord, 8.
This is also
In fact, my lord, this item, till item number 19.
Compliance affidavit is filed.
No, my lord, it can be fixed on 7th of...
Same
matters.
yes, same order. Maybe pass.
Okay, 13 to 19, you write that 13 to 19 or 20?
19.
19.
Okay, 19, huh? You write that it is submitted at the bar that analogous matters are fixed on 7/10/2025, and there is a prayer made that the instant matters may also be listed along with the same. Prayer is allowed. List this matter on 7/10/2025 along with contempt case number 25 of 2019.
Oblige.
Item 20.
My lord, if we may be kindly given another
That
2 weeks' time for...
rejoinder is not filed, but then you see, you have taken so many times.
Yes, my lord.
So many occasions it got adjourned because
My lord,
of that.
if last chance may be given to file the rejoinder affidavit.
You are for respondent number? Or
For
you are petitioner?
the petitioner.
And for the private respondent.
They have taken so many times, right? Okay, heard Mr. Ralte, right? Mr. L. Ralte for Learned Council. Heard Ms.
Latlan Louis.
Okay, for the petitioner. And Mr. Ralte, you are there for? You are Mr. Ralte, right?
No, my lord, I'm Seetlan Thiang Lima for respondent number 5.
Our respondent and so and Zairang Sangkui for state for
Respondent number 1.
respondent number 1. The Ms. So-and-so for the petitioner prays that she may be allowed some more time to file her additional affidavit, rejoinder affidavit. It is seen, full stop, it is seen that on number of occasions this prayer was made. However, it is reiterated today for the ends of justice. Ms. So-and-so is allowed to file her affidavit, a rejoinder affidavit as a last opportunity. List this matter on after 2 weeks.
Yeah, yes, my lord.
List this matter after 2 weeks on a date to be fixed by the registry.
Oblige.
Okay, you file it this time.
Yes, my lord.
Item 21.
This is where I think my last order is there, where it is said that those period is not counted as a qualifying service, right? For
Yes, my lord.
in the senior grade. Now what happened?
My lord, I believe that the affidavit has already been filed by the respondent.
Counter affidavit filed
Yes,
by
my lord.
respondent number 1 to 5.
Yes, my lord.
Firstly, my lord, what I would like to raise is that this is a contempt proceeding, and the affidavit, joint affidavit has been filed, which is not acceptable and permissible.
This is how?
This is
How
impermissible.
can there be a joint affidavit in contempt proceeding?
And secondly, my lord, be that as it may, they have enclosed one order in the said affidavit as in Annexure 2, order dated 1st May 2025. Page number 7 in the
Yes,
affidavit, my lord.
Annexure 2.
The respondent's authority were wholly misconceived in the direction of this court, my lord. I'll
Wait, I'll
clarify
just
that.
read it. Where is judgment? and
Whereas
order?
judgment and order dated 4/7/2024 was passed by the Honorable High Court in WPC number 66/2024, giving the state respondents liberty to verify and scrutinize the service particulars of all the petitioners. And whereas contempt petition number 2 of 2025, in connection with judgment order dated 4/7/2024, was filed by the petitioners. And whereas the service of the petitioners were scrutinized and examined as per the liberty given by the judgment order dated 4/7/2024. And whereas the government have, in the past, made an error of granting the counting of past service on similar case.
Oh, made an error.
Such error made by the government regarding counting of past service should not be interpreted as a precedent to justify future similar case.
That time they did not place.
I'll come to that, my lord. Now, therefore,
the government after careful.
Now, therefore, the government, after careful consideration of all the facts and circumstances, upon exercising the provisions of Clause 3 of the Mizoram Government Employees Counting of Past Service Rules 2020, cannot entertain the petitioner's claim of counting of past service, as the said rule does not entail provisions of counting of past service for direct recruits under the government of Mizoram. What
They did
happened
not
here-
file appeal.
What happened here is that, my lord, there are two things. The first one is that these rules of 2020, which provided to enable only 1/3 of their past service. And the other notification is 2013, which the petitioners were claiming, whereby they can count the entire past service. And our claim before the writ court is that we do not want these rules of 2020, but we should be governed by the notification 2013, wherein we can claim, count all the entire past service. But this
What is the distinction you said, 20 and 13 notification?
rules of 2020, under that we can count only 1/3 of our past service.
1/3.
1/3. And under the 2013 notification, the entire past service. And that is what we are claiming. And the court is, the learned writ court is saying that we should be granted the benefits of 2013, and we will not be covered by rules of 2020.
That is held by the court.
Yes, my lord. But
In the contempt judgment, in the judgment.
yes, my lord.
Achha.
And what the order stated is that we cannot be considered under rules of 2020. We do not want this. This has nothing to do with the petitioners.
Now they are entertained, they are taking to 2020 rules.
They were saying that our case cannot be considered under the rules of the 2020. We do not want rules of the 2020. We are claiming relief under the notification 2013.
And it has already been held by the court.
Yes, my lord. So, my lord, if your lordship may kindly see the judgment
First,
order
one thing you should do is you file separate affidavits.
in a proper manner.
One affidavit on behalf of all the respondents will not do. This is a contempt proceeding.
My lord, there's authorization letter from the respondents.
Even if there is an author, I don't think so in contempt petition, this can be done because your individual liability will be seen.
Yes, my lord. This matter is taken up by Miss Mary, so I'll inform the Miss Mary of this matter.
So, okay, let Miss Mary appear, and regarding affidavits, show us something that it can be done by all the contemners together.
Yes, my lord.
Okay, let Miss Mary come. When do you want?
After 2 weeks, my lord.
Why after 2 weeks? See, this is a flagrant violation, right? 2003 rules will not apply. 2013 notification as has been held by the court. Then on that basis it is said that their past service will be counted. And now you take recourse to 2003 rules. This is not done. This is not how the court's orders should be flouted. You tell Mary to appear tomorrow, day after, or any day.
My lord, she's on leave.
Oh, she's on leave?
Yes, my lord.
So, Victor, Mr. Victor, otherwise there is a flagrant violation. What do you do? But then she is on leave. Okay, heard Mr. Victor L. Ralte, right? For the petitioner and Miss
H.C. Deborah.
Deborah, learned counsel for the respondent number 125. Miss so-and-so appearing for the respondent submits that Miss Mary L. Khiangte, the learned counsel, appears for respondent number 124 and that she is on leave today and has prayed for some time. Prayer is allowed. List this matter on. She is on leave for 2 weeks.
Yes, my lord.
List this matter after 2 weeks on a date to be fixed by the registry. In the meantime, it is directed that the joint affidavit filed by all the respondents may be considered by the joint affidavit filed by respondent for all the respondents may again be considered whether the same is the proper course by the learned counsel appearing for the same. Okay? You bring something, you show something,
my
then
lord.
only we can see. Otherwise, in a prima facie view, it is not permissible.
Item 22.
My lord, I am for respondent number 1 and 4. I filed my affidavit on 29/8/2025, wherein we stated that there is no any willful disobedience of this honorable court order. However, we challenge the order passed by this court in WPC 17D of 2019. Then the writ appeal number 4 of 2024 has been disposed of 2025 only.
2 and 3 are not served. What happened to respondent?
20 has not been served, madam.
Respondent
There
number
is no return of any card from respondent number 2 and 3.
Why? You have taken steps but
Yes,
could
my
not
lord.
be served.
My lord, we have taken steps. However, according to the office note, no return of the ID card, madam. And
1 and 4, you are appearing for 1
Yes,
and
my
4.
lord.
And you have filed your counter.
yes,
Reference unserved, not yet returned back from 2 and 3. So we will await when
My lord.
was the step taken.
my lord, based on the affidavit filed by the incident respondent number 1 and 4, my lord, the appearance of respondent number 2 and 3 will be necessary.
Await for some more time.
My lord,
Heard Mr.
Tila Zakima, my lord.
For the petitioner and Ms. Zairang Sangpui, learned CGS, learned counsel, appearing for respondent number 1 and 4. Ms. Zairang Sangpui states that the affidavit has been filed on behalf of respondent number 1 and 4. Again together.
Together.
1 and 4. 1 and 4 are who?
One is Secretary, Minister of Defense, and 4 is DO, Defense State Officer, Guwahati.
1 and 4, however, the office note dated 4/9/25 reflects that service upon respondent number 2 and 3 are not complete. As such, the service upon the said respondents may be awaited. List this matter after 2 weeks.
My lord.
Yes, ma'am.
After 2 weeks on a date to be fixed by the registry.
Dibly obliged.
Obliged.
Item 23.
objection is not filed?
Yes, my lord, I may address your lordship. I would like to submit in oral submission, if you please. Okay.
I mean, without the objection, you want to...
Yeah, oral submission.
Fine, if it's criminal petition only, what is the need for affidavits and all? This is
that's
for
true,
what?
my lord. Yeah.
For some
That-
addition?
My lord, by filing this criminal petition, I'm seeking for quashing of the order passed by the lower court in criminal complaint number 57 of 2025. The particular order, my lord, that Israeli national, my lord.
Mother was added
Yes,
as
yes,
an
the mother was wrongly added as the co-accused. Initially, my lord, a criminal complaint was filed against the son of the present petitioner.
Oh, I remember the agreement and all. I remember the complaint.
My lord.
Because they got married here and then
Exactly, my
he
lord.
went back and then
My
he
lord.
did not take her back.
My
Yes, I remember. There, of course, I had given stay as far as the mother is
Exactly,
concerned.
my lord, yes.
Now she is made an accused and you have challenged that.
My lord.
My lord, if you, Lord, kindly pardon with me, I'll make a brief story of the case.
Okay, let him finish first.
Okay, my lord. Yeah.
My lord, initially...
I'll just read the order. Wait. This is the order you have challenged.
My lord, yes, this is the order that I have challenged by wrongly adding the petitioner as the co-accused, my lord. Initially, my lord, when the criminal petition was filed before the lower court by
I don't
the...
know, where is the final the statement that she is arraigned as an accused? Attempt due to the accused and unheard.
This is the... My lord, this particular order is the only written record by
But
adding
in
as
the
the
order,
co-accused.
show me the line where she is arraigned as an accused here.
My lord, yes,
Oh,
if I may read, my lord, Parat 2.
Oh,
Parat 2.
Lalnun Ziri.
Yes.
And who son's name is?
Son's
Name
name
is not
is
there.
David.
Okay.
David.
No, has been added as co-accused with respect to this complaint and on ground of cheating.
Yes.
Where is the original order where she was added as a co-accused? Or this is the order.
This is the original order is
Annex
at
of
page
D.
32. Annex of D. This is the scan copy, my lord. Just before that retyped copy.
Oh, this is the type copy.
Yes, my lord.
She was added as an accused on 9/6.
Yes, 9/6. 9/6 only.
Okay.
My lord. And at the time of filing the criminal petition, my lord, or initially the present respondent had filed a criminal complaint against the son of the present petition.
I remember the complaint.
Yes, my lord. Perusal of the criminal complaint shows that
What is
nowhere
this order 29/5/25?
that order was passed, my lord, against the 29/5 is for issuance of the non-bailable warrant of arrest against the present petitioner, my lord.
This is the issuing of summons and thereafter warrant, right?
My lord.
On what basis summons were issued to her? Before arraigned her as an accused?
The basis is that, my lord, since the son is in Israel, so they came, the mother, the present petitioner came from Israel as a tourist to visit their relatives. So a submission was made before the trial court that the mother is presently stationed in Israel. So it may be appropriate to issue summons since the son is in Israel. So on that basis, the summons was issued by the trial court to the mother. And as the mother, who is not a...
Only on that submission?
Yes, only on that submission, yes, my lord. The summons was issued, and as the petitioner failed to appear, then the warrant of arrest was issued, straightforward.
Okay.
And
So
my
on
lord,
what
here
grounds have you challenged this?
I have challenged that careful perusal of the order, that impugn order, dated 9/6/2025, simply shows that the accused Srimati Nunziri has been added as co-accused. This is the only speaking order without any observation, my lord. In any criminal proceeding, cognizance has to be taken at the initial stage. All those aspects are silent in passing this order. Here, it also stated that on the grounds of cheating. So, why she was added as the co-accused on the grounds of cheating? All those observations and statements are absent on perusal of the order passed by this lower court, my lord, trial court. And here also stated that the main accused is her biological son, who refuses to appear in court as he is in Israel. So, appropriate steps in the event of criminal proceeding to be initiated against the son. There are procedures which are to be followed by the the trial court.
You have judgments, some judgments on 311. Some judgments on 300. What?
Yes.
The particular section is 311, right?
I think
Erring is accused?
it's against, it's the particular provision is, my lord, 208, my lord.
In BNSS?
BNSS, my lord, yes.
Earlier it was 311.
Against,
Give it at BNSS. There it is.
actually, my lord,
358, I think. 358 alone.
this is this
Section?
section 208. 208 BNSS.
That is offense committed outside India.
This is outside India.
No, I'm talking about arraying as accused.
Arraying as accused, yes.
That was 311 or something in CRPC.
358, my lord. 358, I think.
$319. Right. She is arrayed as an accused under what provision?
Such provision was not reflected, my lord, in the impugn order.
What is the corresponding section of 319 here in BNSS?
358, my lord.
358.
Yes.
No changes. Same.
Same.
Same. Okay, it is same. So, when was she arraigned as a co-accused? 9/6?
9/6, yes.
9/6.
My lord, 9/6.
During the inquiry trial, at any stage, one can be added as a co-accused, right?
Yes, yes.
If, of course, or if on evidence it is found.
My lord, yes, on
Right.
evidence.
It appears from the evidence that any person not being the accused has committed any offence for which such persons could be tried together with the accused, the court may proceed. Now here, what is the evidence? Do you have any judgments on 319 something you have brought? On what ground a person can be arraigned as a co-accused along with the main accused? There has to be evidence.
Exactly, my lord.
So here in the order, there seems to be no evidence. This is simply said that she was called. She did not appear. Summons were issued. She said no
Exactly.
knowledge, and then there was a nuisance, and then she was made.
Exactly, my lord, yes.
But then the sentence in paragraph 2, you see, the accused has been added as a co-accused with respect to this complaint on the ground of cheating. The main accused is her biological son, is examined, and she stated that she has refused to receive summons served by the council as she allegedly had no knowledge. Right. So it seems she was added as a co-accused earlier. What do you say, Mr.?
My lord, on that 9th June 2025, the petitioner was produced after subsequent summon, and before the learned trial court. The petitioner accused mother was informed and explained all that she had been summoned to show cause about the offences against her son. However, at the time of the court proceeding, because of her erratic behavior in the court, she was sent in judicial custody. At that time, my lord, if the lordship permit, I would like to take BNSS, same as 319 of the CRPC, close one. May I read, my lord? Power to proceed against other persons appearing to be guilty of offense, where in the course of any inquiry into or trial of an offense, it appears from the evidence that any person not being the accused has committed any offense for which such person could be tried together with the accused, the court may proceed against such person for the offense which he appears to have committed. Here, my lord, I would like to submit my one citation.
You need evidence.
Yes, my lord.
To make somebody
Even
else.
before evidence, I would like to submit.
Which paragraph?
Page 36, my lord.
Yes.
Point number 110. Here, it is clearly mentioned in that point number 3, the question number 3, whether the word evidence used in section 319, clause 1 of the CRPC has been used in the comprehensive sense and includes the evidence collected during the investigation, or the word evidence is limited to the evidence recorded during trial. Answer. In Dharampal's AIR 2013 Supreme Court 2018 case, the Constitution Bench has already held that after committal, cognizance of an offense can be taken against a person not named as an accused, but against whom materials are available from the papers filed by the police after completion of investigation. Such cognizance can be taken under Section 193 CRPC, and the session judge need not wait till evidence under Section 319 CRPC become available for summoning an additional accused. Here in the question number 4 also, the next page, what is the nature of the satisfaction required to invoke the power under Section 319 CRPC to arraign an accused? Whether the power under 319 Clause 1 CRPC can be exercised only if the court is satisfied that the accused summoned will in all likelihood be convicted. Though under Section 319 Clause 4 subclause B CRPC, the accused subsequently impleaded is to be treated as if he had been an accused when the court initially took cognizance of the offense. The degree of satisfaction that will be required summoning person under 319 would be the same as for framing a charge. The difference in the degree of satisfaction for summoning the original accused and the subsequent accused is on account of fact that the trial may have already commenced against the original accused, and it is in the course of such trial that materials are disclosed against the newly summoned accused. Fresh summoning of the accused will result in delay of the trial. Therefore, the degree of satisfaction for summoning the accused, original and subsequent, has to be different. Here, my Lord, my submission is that the learned trial court found prima facie materials against the petitioner that are as an accused.
Where is that prima facie satisfaction?
Yeah, because of that, the Honorable Trial Court make an order against the present petitioner.
But you do one thing, you get the order sheets.
Yes, madam.
I want to see the order sheets from beginning. Right, in this case.
My lord.
Get the order sheets.
My lord.
Because I'm not very sure how did they proceed. Because there has to be, now he has placed a judgment saying that the materials would be sufficient. Whatever is collected during the investigation. It need not be evidence.
My lord.
My Lord, if the Lordship permit me, I would like to ventilate the Lordship ideas and view from my submission. From the brief fact of the story, then ventilating the Lordship, then it will be clear, I think.
No, first get me the order sheets of this.
Then we shall go through the order sheet also.
Order sheet is required because you have only annexed few of the orders. So I want to see the entire orders. This is what? This is case number 1 of 8. What is this case number? This order sheet of the magistrate. Please bring it and annex to an affidavit. Now I'll see how did they proceed.
My lord.
Whether the trial against the son is on, charges and all are framed.
Charges.
Or charge sheet is submitted.
No, my lord.
Charge sheet is also not submitted.
Under investigation.
It's like a criminal complaint was submitted, and after the statement of the complainant was taken, and then the cognizance was taken, and then the case was proceed on without filing of the charge sheet, without giving instruction to the prosecution to investigate the matter like that, my lord. There was no such situation.
No, without filing of charge sheet, how can a court enter and say co-accused? This is for the police. Police can involve others also.
Exactly, my lord.
Charge sheet is not submitted here.
Not submitted at all.
And whether 319 can be taken recourse to during investigation.
My Lord, this is the initial stage. This is a complaint case.
You see, in the course of any inquiry or trial of an offence, so what is the definition of inquiry? See definition of inquiry here. Inquiry means every inquiry other than a trial conducted under this code by a magistrate or court. Here investigation is not complete, charge sheet has not been filed. Whether 319 can be taken recourse to now at this stage when charge sheet has not come.
Exactly, my lord.
You bring some judgments on that.
My lord.
Whether it
Right.
can be, because otherwise inquiry means every inquiry other than a trial. That means before charge framing and all. Right?
My lord.
Conducted by this, under this code by a magistrate or court.
My lord.
Now the investigation, the inquiry by police is not over. Police is yet to file charge sheet.
Exactly, my lord.
Please look into that aspect and come.
My lord.
Day after tomorrow or Friday you come.
My lord, that can I.
My lord, if lordship permit, this week I am very tight schedule in other engagement this week. Today also I'm going to Champai, then tomorrow I'm coming back.
Then
and
then do it on next week.
next week.
Monday?
Monday, please.
As for prayed for by the parties, list this matter on Monday. Okay? Give the date. 15th of September. Please bring those
My lord,
judgments here.
my lord, I'll.
Because what I know is arraying an person as co-accused happens during the trial. Now here the inquiry is also there. So what inquiry? Inquiry done by the magistrate or the court? Magistrate or the court has not come into the picture because investigation is not over, charge sheet is not filed.
Exactly.
So
Exactly.
this arraying co-accused may not be proper. Prima
My-
facie what I am thinking is, go into some judgments, I'll also go through.
My lord, will.
On Monday.
Especially for concerning that mother concern, is it?
Mother,
Yeah.
son is okay, investigation is on and all, but police has power to include others as accused. But here, this is not clear. The 1906 order is not clear. She was already arraigned as an accused. Summons are issued. She did not comply with those. Then, on the strength of NVWA, she was arrested or brought, it is said?
Arrested.
Arrested.
My lord.
And then,
She was
and then
discharged for
Detained
bail.
in judicial custody.
She's in bail now.
she is on bail now?
Yes, my lord.
She is on bail now. But look into that.
My lord.
Whether
will
the
do it.
1906 order is proper. Okay?
My lord, my lord.
Get some
My
judgments.
lord. Oblige.
I'm ekdam not well. Or part 2 matters? Okay, whatever you call, just call it.
Item 24 for orders.
I think here amicus only. This is an appeal filed by the appellant from jail against the judgment dated 2/8/2023 passed by the learned judge, Special Court, NDPS Act, by which the applicant was convicted and sentenced or convicted under section 21C of the NDPS Act and was sentenced to RI for 10 years with fine and default stipulation. It is noticed that the paper book is prepared and the matter and what is left is to appoint an amicus curiae. As such, this is legal aid, right? Amicus is also same?
We don't have a separate.
Okay. Mr. Jordan Romingtonga is appointed as the amicus curiae to defend the appellant in this case. List the matter after 2 weeks. Oh, the registry is directed to serve the copies upon the learned amicus curiae. Serve the paper book upon the learned amicus curiae. List this matter after 2 weeks on a date to be fixed by the registry. Part 2 matters? None. No one is there. Yes, Miss Linda, no one is there for part 2?
I believe no one is here, my lord, for now. Maybe.
Acha. Otherwise, item number 1 is for tomorrow, right?
Yes, Lord.
Fixed item is there for tomorrow.
Okay, inform the councils if you can,
Yes, my lord.
so that they are taken up. Okay?
All right.